Good afternoon, everybody, and welcome to this virtual workshop on the commercialization and intellectual property protection of Earth observation-derived products. I'm Craig Jacobs, the Business Development Director of ARGANS, leading this European Space Agency Commission project called Building Trust in the Digital Economy, with our partners at the Centre for Commercial Law Studies of Queen Mary University, London. The aim of the project is to look at intellectual property protection and potential technical solutions to support legal enforcement of ownership rights and data processing of Earth observation products as these move to the cloud computing environment. During our project, we have reviewed the legal and technical environment, engaged extensively with stakeholders in the legal, blockchain, cloud computing, Earth observation, and satellite data communities. The stakeholder engagement has included a survey, in-depth interviews, a workshop, and 2 side meetings at the European Space Agency's Phi Week. We have mapped the data flows of 4 projects delivering Earth observation products and developed a proof of concept blockchain solution for the registration of digital assets that allows for easy, cheap, and huge data of Earth observation products. The space industry is in a stage of substantial growth, and Earth observation from satellites offer the ability to monitor the Earth, including for climate change and the environment, cost effectively and at global scale. It is, however, an ecosystem populated by a large number of research and development startups and SMEs. As these companies evolve and develop commercial products, their understanding and execution of strategies to protect their intellectual property and data is an essential component of value creation and accelerating growth. The European Space Agency has extended this project in order to enable us to expand our work and also to build on the great collaboration we have developed with CCLS over the last couple of years. I'd like to thank our partners at CCLS for hosting this workshop and the European Space Agency for funding this project. And I now hand over to Naam Shemtov.
Thank you, Craig, and thank you, ESA, the European Space Agency, for indeed making this project, facilitating the project and making it happen. Before I hand you over to Michaela, who we are all grateful for actually arranging the conference, and she would present both the topics and our eminent speakers. I just want to share with you before I hand the mic over to her, my overall sentiment. I mean, during more than a few years that I've been working with people from the scientific community, which is quite refreshing in comparison to lawyers sometimes, what became clear to me, and that definitely repeated itself within this project, is the clear need and willingness to learn also on the side of the scientific community and the research community about, so to speak, a legal road mapping of the relevant issues which concern their areas of research and work. Now, that applies, of course, to actors in the space sector, some of which we had an opportunity to engage with. And it's clear that these people are doing excellent and exciting work in their field, but also quite clear that could benefit from both IP and quasi-IP protection. I mean, it is clarifying the picture in this context, which is one of the key objectives of this project. And with this, I will hand you over to Michaela. Thank you.
Thanks, Craig and Noam, and welcome everyone here to our second workshop associated with this project. Now, I would like to introduce our first speaker, who is John Hull. John teaches at Queen Mary, as well as King's College London and the Monash University in Melbourne. He specializes in commercialization of intellectual property and trade secrets. He's also a practicing solicitor, previously a partner at Dentons and at Eversheds, specializing in intellectual property and data protection. and he is currently a consultant with Impact IP, a patent attorney and legal practice based in London. As we have discovered through our project, our year-long research into the Earth observation ecosystem, the technological, legal, and regulatory landscape is very complex, and it's particularly difficult to navigate for SMEs and for startups who usually do not have the necessary resources, knowledge, or experience to figure out all the different factors that are needed to be taken into consideration in order to successfully exploit and commercialize Earth observation data on a large scale. So we are really grateful to have John here today with us with his vast expertise in both practicing in this particular area and also teaching about commercialization of IP. And I'm really looking forward to listen to John to talk us through the essentials when it comes to exploitation and commercialization of intellectual property, which in this context will be linked and derived from Earth observation data. We do hope that this workshop, both sessions, will contribute to a greater understanding of intellectual property, of licenses and contracts, enabling SMEs and startups to develop robust and ambitious intellectual property strategies and best practices. And ultimately, that it will contribute to building trust in the digital economy, which was or is the overarching aim of this project. And now over to you, John.
Michaela, thank you very much, and good afternoon, everybody. Give me just a second to bring up my presentation, which I hope you can see there. What I'm going to talk about this afternoon is akin to a process of alchemy, in the sense that when I was first asked to do this presentation, I tried to think about something which would give me a guidance, because this is a relatively new area to me, and what I was trying to convey to people attending this session this afternoon. And alchemy, as many of you will know, is a process of attempting to turn base metals into gold. And the analogy stretches, so far as this afternoon is concerned, to a process of thinking about how raw data, in this case, Earth observation data, is or can be processed and converted into something which I will call a derivative product eventually. Okay, let me just start with a definition of what I mean by commercialization. What I mean by commercialization is the production of something from which you derive a profit or which is capable of being exploited. And of course, so far as this afternoon is concerned, we're thinking about the creation of profit or the exploitation of an intangible property right, intellectual property right. Now, there are a great many myths about intellectual property, and in particular about how to derive money from it. And what I want to do in a slide, which I hope will come up in just a moment when Chris, the expert, is making them available to us, is to look at some of those myths about intellectual property. Hopefully I can, yes, there's my definition of commercialization. And here I want to move to, if I can, some myths about the commercialization of intellectual property. And on the left-hand side, you see a large no, and on the right-hand side, you'll see a series of provisions, intellectual property, contract income. Let me just explain that. Unless you own or control some intellectual property, you're unlikely to get any kind of contractual right to use it. If you don't have a contractual right to use it, you're not going to get an income. And let me start with this first myth about intellectual property, which is that if you've got some intellectual property, it guarantees you an income. No, it does not. Another myth, which perhaps I'll use just to precede what I'm going to say now, is that getting intellectual property is the hard part. No, it's not. Using intellectual property and creating something from it is the hard part. Patent attorneys, intellectual property lawyers will tell you that getting intellectual property rights is relatively easy. And as we come to the end of this presentation and I deal with copyright and databases, we'll see that the derivation of a valuable piece of intellectual property, copyright or a database right, is relatively easily achieved. Another myth, let's just dispel a few of these before I move on. Another myth about intellectual property is that intellectual property equals patents. No, it does not. I'll spend very little time, if any, talking about patents because it seems to me that, except in really quite unusual circumstances, they really don't apply to the kind of material that I'm going to look at this afternoon. Perhaps one more myth. Intellectual property rights are expensive and you can leave it until you've got money to be able to afford them. No, they're not. Copyright and databases, which are the two main focuses of my discussion this afternoon, are relatively easy to acquire. They're cheap and relatively freely available. Patents are not. You've got to go somewhere to get them registered. But we're not talking about patents here, so let's not conflate too many things. Let's dispel some of those myths about intellectual property. But the one that I want to emphasize here is this key one on the screen in front of you now. Unless you have some intellectual property, you won't be able to create any contractual rights which come out of that, something I'm going to look at a little bit later. Unless you've got a contract, you won't be able to derive an income. So the existence and ownership of intellectual property rights does not make it inevitable that you're going to be able to generate some kind of valuable income from it. If I move on to what I'm going to talk about this afternoon, it's in 5 stages. So if I could just move to the next slide, if somebody could help me do that. I'm going to go through a 5-stage process. First, I'm going to look at accessing raw Earth observation data. Secondly, I'm going to look at understanding and paying for the right to use and process that data. Third, I'm going to look at the creation of a new process or service, more obviously a product or a service, which I've called a derivative here. Fourth, I'm going to look at the intellectual property rights which are likely to protect that newly created derivative product or service. And I'm going to spend some time right at the end looking at the best method to commercialize the derivatives. So let me go to step 1 in this process. Somebody push me to step 1. Accessing raw Earth observation data. And if I can go to the next slide, please. The sources of Earth observation data are derived from the Copernicus, previously Sentinel program. And they are basically data from Earth observation satellites, from some commercial satellites, and from potentially sources based in the Earth. And we've got a definition there of Sentinel data, all data and products generated on the observations acquired through sensors in Sentinel missions and so on. And I have to admit here that this is where my knowledge of how the process works is somewhat deficient. I don't really know what this raw data consists of or looks like. I'm going to make an assumption that it is binary data, which in its raw form is really utterly unusable. It has to be converted into something else. And obviously that's the process that I'm going to be looking at as we go through this presentation. Why provide access to Earth observation data? This is the explanation that the European Commission itself provides. To give or provide accurate and reliable information in the field of environmental and security, and to contribute reaching the objective of the Europe 2020 strategy by developing an effective space policy and so on. So we've got an explanation to why this Earth observation data derived from European Space Agency and indeed other commercial operators is going to be made available to the general public. We can go to the next slide, please. How is it made available? Well, it's divided into Copernicus data and Copernicus information. This is a distinction which is not readily apparent to me, because if we look at the first one, it's dedicated mission data. In other words, what I assume is simply binary information beamed to Earth receiving stations from the European Space Agency satellites and other satellites. But then it becomes something slightly different, Copernicus information, which is information following processing or modeling of Copernicus data. Now, it's unclear to me, looking at, and you can see this is from the basic regulation which provides access to Copernicus data, that's Regulation 377, an EU document, what the distinction is between these two things. Nonetheless, this is something we've got to bear in mind as we work our way through. Where is it available? Well, it's available from cloud-based data storage and processing sites, and I've given an indication in the second bullet point of that second paragraph where these are, the DIAS system and other sources of data. The data may also come from national EU state platforms and also, of course, from commercial operators who who have been the beneficiaries to some extent of this raw data and who have processed it in order to make it available on a commercial and not necessarily a free basis to those who wish to use it. So we have in this first stage an idea of what the data is, where it can be found, and how the European Commission, or why the European Commission wants to make it available to data users. Can we go on to the next slide, please? Step 2, understanding and paying for the right to use Earth observation data. Why have I given some emphasis to the idea of paying for the following reason. In principle, this is raw data which is made available, as we'll see, on a fair, free, and open basis. And we need to understand at this basic stage that there are issues of ownership which emerge. And the European Union claims to own property rights in raw and unstructured data. And we find that from Regulation 377, this is Article 28, the Union shall be the owner of all tangible and intangible assets created or developed under Copernicus. It doesn't actually identify what those intellectual property rights are, which is slightly difficult because we've got to try and figure that out for ourselves. And it also needs to be married up to the terms and conditions of the European Space Agency and European Commission, because those are also relevant. And I'll give you some references to these in just a moment. They're also relevant to helping us understand the basis upon which users get access to what this stage seems to me to be basic raw data. Because the terms and conditions say that the intellectual property rights in primary or altered products belongs to the satellite owner. I'm going to assume, for the sake of argument here, because I don't know the answer to this, that the European Commission is ultimately has some kind of ownership rights of the satellite in question. So we got a number of slightly confusing elements at this first or second stage of my consideration. We got primary and altered data, and we have raw data. Nonetheless, we have a claim to ownership of the data or intellectual property rights in it. And the question is, on what basis we're going to get our hands on it. Can I go to the next slide, please? And building on that, we have now to understand the basis upon which users who want to make some kind of commercial use of this to create derivative products have that right to use. Now, as I say, it comes on the basis of a free, full, and open FFO basis, and that is set out in the fundamental document, Regulation 377, which I've already referred to. There are, however, a couple of other things we need to build on that notion of free, full, and open access. And we find that in the legal notice and in a regulation to Regulation 377, explaining that the license that people get to use this raw data is a license to reproduce, to distribute, to communicate, to adapt, modify, and combine, or do any combination of those things. And this fundamental basic license to use raw unstructured data is going to be a time unlimited, perpetual in other words, and non-exclusive license. I think everybody will understand the notion of a non-exclusive license being that there will be any number of licenses which are created according to the number of people who wish to use the data concerned. It's also important to note that this raw data license is an as-is license, so there are no implied or express warranties as to the quality or suitability of this data. Put bluntly, if you take a license to use the raw data, you take the risk that it's going to be the best thing that you need for your business opportunities or what you want to create using it, an as-is license. And the terms and conditions, the European Space Agency EU terms and conditions, which I referred to a few moments ago, show us that the license is intended so that users can produce derivative products which contain a significant intellectual or creative achievement. And it's the reference to those words, a significant intellectual or creative achievement, which takes us into a state of creating something which intellectual property rights can recognize, as opposed to raw data. And in normal circumstances, I would say pure rights in information or data as such do not generate intellectual property rights. But of course, we've seen from the preceding slide that the European Commission slightly differs from my view and thinks that it owns some sort of unspecified intellectual property rights in that data, which of course explains why we can now look at, or we're looking at, the terms upon which it's made available to people who want to use it. Can we turn to the next slide, please?
Apologies, John, slight technical hitch here. I'll get there in a second. You carry on, I'll make it work.
Okay. The next slide is simply a listing of a couple of documents I've already identified for you, and I've called those the key legal documents you need to know something about. I made a reference already to this basic document, that's Regulation 377, which establishes the Copernicus program and which gives us some guidance about what others are likely or entitled to do with the data. The regulation here, which is called Delegated Regulation 1159, is also important because they were made under the prior regime, in other words, prior to 377, but nonetheless 377 and 1159 need to be read together in order to understand the basis on which the European Commission entitles users to use the rights that we've already begun to understand. There are some terms and conditions on the use of sentinel data, and again I've made a quick reference to those already. And there is a very short legal notice on the use of Copernicus sentinel data, and that's a slightly curious document because it also contains a reference to the Copernicus sentinel data policy, a document which I have searched high and low to find and cannot find any reference to at all other than in that legal notice. In other words, it's something that doesn't appear to exist. So if you're trying to understand the legal regime which wraps itself around this, these are the documents which provide the relevant process of taking that raw data and having the ability to convert it into something else. Can I go to the next legal document, or the next document, please? So say, there are some limitations on this EU license because, as I describe it here, it is a necessary but not sufficient document or entitlement to allow users to create those commercially viable derivative products. Why is it not sufficient? Because you need to have access to other third-party rights and probably to other third-party processing resources in order to create something. So because the EU license does not take account of third-party intellectual property rights, in other words, intellectual property rights which exist in data coming from other sources, for example, third parties who own in situ sources. So if you're taking raw data from the satellite, but you need to combine it with information or data which comes from a third-party source, then it may well be that you've got to take an intellectual property right from that third-party owner in order to combine the two things together to create your derivative product. If that's the case, then it's highly likely that that third-party license is going to be on standard, non-negotiable terms. It will contain few, if any, warranties. To that extent, it will replicate the EU license, whose terms we looked at just a moment ago. It may be a paid-for license. It may be subject to some royalty-driven license terms, and it may well be subject to third-party law and dispute resolution processes in another state. So if, in order to create your derivative work, you're having to get access to other people's intellectual property, one of the first things you're going to have to do is to make sure that you're operating within the terms of the license that you get, and that you observe and are conversant with any limitations, particularly the fact there will be few, if any, warranties or assurances about the quality or sustainability of the data you're getting from that third-party source. So if you need to combine these things together, these are the kind of considerations you're going to have in mind. Of course, you're also going to have to pay, in all probability, to access those cloud-based services for the processing of your data. It's most likely that people will be using cloud-based services, in which case, if you're using the software as a service or the platform as a service, you'll need to comply with the cloud provider's service agreement and any limitations on what you're entitled to do with the processing of data in that way. So although you get free, fair, and open access to EU raw data, it's certainly not going to do the kind of job that you need to do unless you also think about cloud service providers, services, and also data and provision of intellectual property rights from another source. Can we go to the next slide, please? Thanks, Chris. This is step 3. So we've worked our way from raw data to accessing that raw data. And now step 3, I want to look at creating new derivative products. Can we go to the next slide? What I've done here is, and this gave me a good deal of information about the kind of things that users of this raw data have actually produced. And I've given just a few illustrations here. They come incidentally from the PwC Copernicus market report on 2019. And although that's a fairly lengthy document, it has got some really quite useful information about how people are using this. So we got a couple of examples here. Gaia Sense, a smart farming tool, providing what they call digital counseling. Not entirely sure what that means. Obviously just the kind of information that farmers will need in certain parts of the world in order to maximize their use of crops, rotation, weather forecasts, and so on. Reticus, slightly similar process for aquaculture professionals, monitoring production sites, advising on breeding seasons, and so on. So these are all pretty good examples of the way in which raw data has been converted into usually site-based licensing arrangements for the people, the commercial operators who are making these kind of derivative works available. And just before I leave that slide, just looking at the third product or service there, Reticus, you'll notice there's a small R in the circle indicating that the word Reticus is a registered trademark. So obviously people who are developing these kind of services and who are developing original distinctive names for their product or service are also taking one further step in the intellectual property chain and protecting not just the product or the service, but also the name by which it is associated. So quite an aside that intellectual property right doesn't necessarily stop with the manipulation of the data, it also goes to the way in which it is it put out to the public at large. Can we go to the next slide? And here, really just pausing into an area where I'm going to spend a little bit more time in a few moments, just to dwell on intellectual property rights, because we're talking about intellectual property in these derivative works. Intellectual property are national rights. They exist on a country by country basis. They are negative rights. They are rights to stop rather than rights to do. So when I started the presentation and I said to you that the possession of an intellectual property right didn't give you an automatic guarantee of an income, this is precisely what I mean. I can use my intellectual property to stop others infringing my rights. But if I want to turn that into an earning potential, I need to create some positive right rather than the negative right that they provide. And inevitably, that is going to be by creating some kind of contractual right. In other words, a contract to do what would otherwise infringe my intellectual property rights. So that's what I meant when I said, no intellectual property, no contract, no income. This is really sort of coming home to explain why I started it in that way. Intellectual property rights are property rights. They are valuable business assets, and they will enhance the business reputation and obviously the quality and the value of the business as an overall proposition. As I say, owning an intellectual property does not necessarily guarantee you an income, and the commercialization process may be a sale, an outright sale, more usually a license. But of course, if you're going to grant licenses or you're going to sell your intellectual property, the chances are that whoever takes the license or chooses to buy the intellectual property rights will want some assurance that you own it and that you have a right to license and sell on the basis that I've just described. If I go to the next slide, please, Chris. Thank you. So creating an Earth observation derivative work, well, picking up what I said a couple of moments ago, you'll almost certainly need to access third-party rights. You'll need to delve into the detail of a service agreement from your cloud service provider, either as software as a service or platform as a service. You'll need third-party access agreements for any independent data sources and so on. And once you've put that together, the most likely form of derivative work is probably going to be a database protected by copyright or database rights, potentially confidential information held potentially in the form of database or software. And as I said earlier, it is difficult for me to see anything in the scope for patent protection, despite the fact that people tend to equate intellectual property with patents, for anything which I've identified as an Earth observation derived work. Chris, can I go to the next slide? So step 4, working out which intellectual property right it is, which is highly likely or most likely to protect your derivative work or service. Next slide, please. Databases seem to me to be the most likely source of protection for the kind of derivative works which are most likely to emerge from the manipulation or adaptation of raw data. And I think that these will be a significant focus for the scheme of derivative works likely to emerge in this area. Now, the content and structure of a database can be protected as a copyright work in the UK, provided there is a sufficiently intellectually creative effort involved. Bear in mind that when I talk about intellectual property rights, including databases, we are talking about national rights. So you always need to think about what the law is in the country concerned. So the fact that UK law or the law operating in other EU countries has a particular focus does not mean that that is necessarily the case in other countries. So if we're looking to protect those databases elsewhere in the world, we need also to think about the application of what national law does and says about their creation, the basis upon which they're protected, and the efficacy of that protection. So we've got the potential for copyright to protect our database, at least in the UK and the EU. And EU law has also introduced what is called a sui generis, a self-standing database right, which doesn't protect the intellectual effort which goes into marshalling the content together. It protects the way in which the database owner has invested time, money, and effort in creating a database. And this is referred to as protecting the verification or presentation of the database. So we have two potential forms of intellectual property to protect what is likely to be the kind of one of the main sources of rights emerging from raw data. Both copyright and database right are intellectual property rights. Therefore, they can be sold as a valuable business asset, or more likely, licensed in the same way as other intellectual property rights. And if we go to the next slide, you'll see that I've attempted to sort of draw a comparative table between the copyright protection, the database direction. I'm not going to say too much about that, other than to emphasize the fact that this sui generis right is an EU, a European Union only intellectual property right, which emphasizes the fact that if you're thinking about data protection, database protection in other areas of the world, you need to think about what the law, the applicable law is in the country concerned. The copyright, if you're fortunate enough to have copyright protecting your database, it's a long-lasting right because it's the author's life plus 70 years. But of course, the point about the database is that it will be continually shifting and modifying its content as more data comes in and is adapted and manipulated in order to fit the requirements of the database and the users or licensees of that database. One of the benefits of copyright and database rights is, of course, that they are automatic and cost-free. These are not registered rights. They're not like patents or trademarks. You don't have to go anywhere to get them. And that, of course, is the ultimate or one of the most significant benefits of having what I'll call freely available intellectual property rights to protect this kind of manipulated data. Chris, can I go to the next slide, please? Step 5 of my process looks at the best method to commercialize the derivative work. And if we can go to the next slide, Chris, what I've done here is really to flag up a number of commercial issues, because we're at stage 5, we're thinking about the way in which we earn money. We commercially use the derivative work which has been created, hopefully, and protected in a potential variety of ways from raw data. So this looks at the method of commercialization. And these are a few general words of warning about the way in which businesses or creators will need to think about using their newly created rights. If you're going to be talking to others in this field, potential investors, joint venturers, collaborators, and so on, you'll need to think about using a non-disclosure agreement. As I say, use them cautiously and be sure to record any confidential information you're disclosing as part of that business process. Similarly, beware of an insistence by the other side on using their own non-disclosure agreement. Do not, under any circumstances, conduct business to generate income from your new derivative work on the basis of an oral or gentleman's handshake deal. Beware also the use of memorandum of understanding, beloved of universities, particularly in the UK, but really they're sometimes what we call a letter of intent, a heads of term. They're meant to be outline agreements only. If you do sign a memorandum of understanding, a heads of terms, or a letter of intent, make sure that you don't use that as the main agreement. Move on and get a better version of the agreement as intended by these MOUs, letters of intent, and so on. Beware the use of standard template agreements. It's very tempting simply to pay a relatively small sum of money for a template agreement, which anybody can buy from the internet. You need to make sure that the agreement you use, your license agreement, whatever it is fit for purpose and is designed to fit your business and what you want to get out of it. And take account of contracts which are subject to foreign law, particularly if dispute resolution provisions are there and they are exclusively assigned to a foreign country. So these are some sort of words of warning in a fairly general sense from me about the commercialization of intellectual property. Can we just move on to the next slide? Thank you. And just to advance something I'm going to talk about in a little more detail on licensing in just a moment, let's understand that a license is based on the licensor's property rights. In other words, the intellectual property that you've created in your derivative work. When you license somebody else to use it, or indeed when you're taking a license of third-party rights in the way that I've described, you're not obtaining any property. You've simply got a contractual right to do something which would otherwise infringe a third party's rights. Or in your case, if you're the licensor, you're giving somebody the right to do something which would otherwise infringe your own intellectual property rights in this case, your derivative work. Remember, intellectual property rights are national rights. That means, of course, that you can expand the range of licensees according to different territories. In other words, you can have multiple licensees, possibly on the same kind of terms, but on a territorially divided basis. Chris, can I go to the next slide, please? And this really just expands a little bit on what I said. The license is a permission to do something which would otherwise be an infringement. It's permission to use from the IP owner to the licensee, usually in return for a payment. Payment might be a one-off payment, the kind of payment you get for a standard software license, or it might be royalty-based depending on what the licensee is entitled to do with it. Inevitably, it will usually contain more merely than that. Permission to use, there will usually be some warranties, some kind of promises from the licensor as to his ownership of the rights concerned, possibly to their validity, possibly to some kind of promise that they will deliver some degree of quality into the hands of the licensee. There may be provisions for updating the license or providing technical assistance, possibly some kind of software provision alongside the license to use a database. There may be performance obligations by the licensee that he will use his best endeavors or best efforts to make best commercial use of the rights which have been put into his hands. Obviously, because the licensor, if it's a royalty-driven agreement, wants to maximize the amount of money he's going to earn and so on. So these are all the kind of provisions you would expect to see in a fairly standard license agreement. Chris, can we go to the next slide, please? And it seems to me really focusing on the kind of database provision that I've highlighted on so far, that a site or content license based upon the creation of a constantly shifting database of manipulated raw data into a derivative product is most likely to be the kind of example we're going to see. So going back to those examples I chose from the PwC Copernicus report, we could see that what GaiaSense or Reticus, the ones that I specifically mentioned, were doing was to make available a database, a shifting database of content, obviously amended on a continuous basis for the users. In the GaiaSense, it was the farming one. In the Reticus, it was the aquaculture one, for those people who bought a site license, in other words, to allow them to get access to the database and to use the product of the database on an agreed basis. And what I've done in this slide is to try and encompass the kind of provisions you would expect to see in that sort of site and content license. It's going to be a non-exclusive license, obviously, because you're going to be licensing it to as many licensees as you can bring into the net. It will be for specified business purposes. So the grant provision in your license will explain on what terms and for what purposes the licensee can use the derivative product. So it will give you an idea of the extent of the grant to access, to view, to download, to print, to distribute, and so on, but probably not to sublicense to others. In other words, the license is your opportunity contractually to control what your licensee does with your valuable derivative product. So say it may be combined with some sort of software which is needed to effectively use the data more effectively. Payment terms, one-time fully paid up license, which I suggest here is probably unlikely in a site or content license, and is more likely to be based on a fee, a subscription service fee, possibly scalable so that people pay according to the amount of use they make of it. I would like to think that there was probably no warranty for licensors of this kind of product, but of course, the commercial reality is that many users may want some kind of warranty, even if it is just a limited warranty on the fact that you own the relevant intellectual property rights concerned. You will want to exclude your liability for use which is made of the data. In other words, to the maximum extent possible, you want to make this an as-is license. What you choose to do with it is up to you, a little bit like a standard software license. I'm happy to give you a license to use the software, but I've got no control over what you're going to do with it. So I'm not going to be liable for any errors or problems which arise from the way in which it is used. There may be compliance with third-party intellectual property rights if you have to combine it with something else. You will have a governing law and so on. So these are the kind of things that you need to think about when generating your earning potential from a derivative product. And in that final bullet point on the slide, I've given you a kind of example which is freely available to look at the Reuters standard terms and conditions. That will give you some sense of what a subscription, a site content license looks like. So if you're in the business of thinking about creating something in a derivative, creating a derivative work, then you can get some kind of idea of the scope of the agreement, the kind of things it will cater for and it will contain by having a look at those Reuters standard terms and conditions. Yes, a completely different field, but nonetheless, the kind of legal documentation is the sort of thing that you're going to be thinking about. And my final slide, Chris, please. It also seems to me that there is some scope here for a mobile app development. And when we look back at those examples of derivative products, which I got from the PW series report, there was one which was called Discover. It was the final example on that particular slide, if you want to go back and have a look at it. And I've given you a link to the site. That's a tourist-based downloadable app, which combines data on air quality, UV index, and environmental conditions such as pollen. So if you're going to a foreign country and you want to make available to tourists a mobile app which combines those kind of features which are readily available from the manipulation of raw data, then that's another potential source of commercialization. And I've given you some kind of ideas here of the scope of IP protection. It's going to be copyright. There may be some limited role here for patents in the software, which may have some kind of technical effect. I'm just going to leave that one on one side for the time being. Third-party contributors, those who assist you to create the app, for example, its graphics, well, you need to think quite carefully of making sure that you own the rights which are created for you by third parties. That's a really quite important feature of thinking about commercialization. You need to think that about your contract with the App Store through which it is made available to members of the public, the terms and conditions on which it's made available to the public, and particularly the role of things like consumer protection and data protection issues which emerge from, in different countries, from the collection and manipulation of personal data from those who are using it. And of course, if people are going to take your app, if indeed that is your derivative product, then you'll need to work out on what basis they're going to pay for it. Is it one-off? Is it a trial? Is a freemium, a subscription model, an in-app purchase, and so on? So there really is in my last slide, an example of a kind of commercial product and the thought process which needs to go into making sure that it is a complete product with all of the intellectual property rights to the maximum extent possible in your hands, but also giving some idea of the kind of potential complexities of making that kind of product available to third parties. And on that basis, I've really come to the end of this presentation. Obviously, I'm happy to take comments and questions.
Thank you very much, John, for this very detailed walkthrough of what you so adeptly call the alchemy in relation to commercialization of Earth observation data. Also, thank you, Chris, for saving the day and dealing with the presentation and moving the slides along. We really
thank you. Yes, thank you, Chris.
Appreciate it. So with this, I'm going to open the floor for questions and comments to our audience. You can either post questions in the chat, or you can simply unmute yourself and switch your video on and ask questions directly.
Maybe I can start with a question. When we look at the different licenses for different data sources, so obviously the Sentinel data is a huge part of what we use in Earth observation, but there are also the very high resolution satellites from different commercial providers. The licenses we find are relatively straightforward when we're just doing research and development. And we also have access often through the European Space Agency to commercial satellite data for research and development. Mm. The challenge is when we move that to real commercial products and services, in which case the cost and the actual complexity of the licenses increases a lot. Are you aware of any industries where different data sources have sought to kind of standardize the way that they license the products in order to facilitate growth of the end products of that data?
I can't immediately think of one at this stage. It may well be that I can in the course of the afternoon. If so, then I will come in and provide some more information. But nothing immediately occurs. You're right to draw a distinction between the very simple form of license, which comes from the European Space Agency. I've got it in front of me now. It runs to no more than 2 pages. User rights, non-exclusive, time unlimited, to use, alter, and modify, to create and distribute derivative products. That's in effect all it says. And certainly if you turn then to the kind of commercial license you're going to get from a commercial provider, it's entirely predictable that that would be a much more complex license with a much more restricted range of things you can do, the kind of warranties or the lack of warranties which may come from the licensor, but confusingly also potentially a series of indemnities coming from you as licensee for their benefit. And just to explain for the audience, that to make sure that they understand what I've just said, if I'm a licensor of a piece of software or data, I might be prepared to license it to you on the basis that I'm not going to give you any warranties. It is an as-is license in the way that I've described. However, in order to protect myself from any use you may make of it, which potentially causes me damage, I might want you to indemnify me, in other words, to compensate me for any damage or financial loss which I may suffer if a third party happens to come to me and say, wait a minute, you're the licensor of all of this stuff. Had it not been for you, this licensee wouldn't have done something which has damaged my interests. Now I'm going to sue you. So to the maximum extent, I tried to create a financial protection in the form of an indemnity. And it's a curiosity, of course, that many of us as software licensees don't seem to realize, because we press the I agree button every time we want it, that we're also giving a whole series of indemnities to the guy who's actually licensing in the first place. So it's a good question, and it allows me to emphasize the need to pay quite careful attention to third-party rights which you're going to get access to in order to make your derivative products. It's not just a question of thinking on the free, full, and open access basis that the EU gives us, because there are an awful lot of things coming in from third-party sources which are going to be a great deal more complex and onerous than that. But coming back to your original question, can I think of any unified data sources? Presently, I can't, but if I can, later on, I will contribute a few thoughts later.
Thank you very much, John.
Thanks,
there is
John.
a question in the chat function. Shall I just go to that, Michaela?
Go for it.
Okay. Does the European Space Agency license have a requirement the source of the data is acknowledged in your derived product? I think the answer is yes, because I've seen it somewhere, and it basically says that you're obliged to say where it comes from. I'm just looking at through the ESA license at the moment, and I can't actually see it there, but if I look at the legal notice on the use of Copernicus Sentinel data and service information, that's one of the documents I've highlighted in the presentation. There is a provision there that basically says whether the user communicates to the public or distributes Copernicus Sentinel data, he or she shall inform the recipients of the source of the data, and then it gives the form of a specific notice, Copernicus Sentinel data, the relevant year, and so on. So that appears in the European Commission legal notice. It doesn't appear, I don't think, in the ESA legal terms, but yes, it is there.
Thanks for answering, John. I have one follow-up question.
I was going to say, might I just chip in on that last point, John, because it made me think of something, that there might actually be a legal advantage to telling people that the data you use derives from Copernicus data, because it might actually help your limitation of liability by pointing out that the source is from somebody else, and therefore it's only as reliable as Copernicus is. You can't make any promises about it, and therefore you're not making any promises onward to somebody else, because there is control over limitation clauses in the UK by things like the Unfair Contract Terms Act and different provisions in other countries. Yeah. So you want to make sure that your limitation is likely to work, and this might help.
Yeah, it's a perfectly good point. In other words, nothing to do with me, Gov, it's all to do with the European Union, because that's where I got this stuff in the first place. Whether it would work is, of course, a different issue, because the user may well be saying, well, it's all very well, but you took the raw data and converted into something, and it's the something that you converted into that I'm using. It may help to sort of defray some of that responsibility. And certainly I would use every possible excuse available to me if indeed I was faced with that potential claim from somebody who'd used my database or my subscription service or whatever it is, and were then likely to complain that somehow it had damaged their interests or caused them loss in some way. Certainly, by the way, of course, one other thing that I tend to tell my students all the time, there are provisions for insurances in all of these areas. So don't forget that if you're creating these kind of services or products that go to third parties, it'd be quite nice to take out an insurance policy to give you some degree of protection for precisely the kind of thing that we've been talking about over the last few minutes.
Thanks, John. I also had a follow-up question on this. Given what you've talked about, the various regulations and licenses that's attached to Earth observation data, and then subsequently the different intellectual property rights that may attach to your own intellectual property, but also third-party property and any services, that cloud-based services that you would be using. This gives us a really complex snapshot of the legal, regulatory, but also technical landscape. Do you think there is something feasible that could be done to simplify the ecosystem a little bit? Is there one or two things that you can think of that may sort of create a path for more accessible ecosystem for especially smaller companies and startups that may lack the resources and experience to decipher, to figure out this complexity? Thanks.
The example that springs to mind is relates to the way in which UK universities make their intellectual property rights available to potential licensees or joint venturers or other collaborators. About 15 years ago, the government was concerned that there was a lack of uniformity in this area, and it encouraged the use of a series of standard form agreements. Those are called the Lambert agreements, and they're freely available. If you simply type Lambert agreements, you can come up with a whole series of patent licenses, copyright licenses, and so on. It seems to me that the European Commission might well be encouraged to generate a series of standard form agreements which small and medium-sized enterprises could use as the basis for accessing this information, for combining it with third-party rights and third-party information, and trying to put themselves into a better position in order to commercialize the kind of things that we've discussed this afternoon. So I think that they're trying to create and define a path through which people with restricted resources, small and medium-sized enterprises in particular, could take advantage of what, in essence, at its most basic point, is raw and unstructured data, might well be a beneficial way to make life easier for all concerned. Because otherwise, you're looking at a plethora of potentially really quite complex documents, some with foreign law provisions, and it's hard enough for experienced lawyers to get their head around this kind of stuff. It must be extremely difficult and really quite very difficult indeed for small and medium-sized companies which don't have that kind of level of resource or inbuilt ability.
Thank you. There definitely seems to be a lack of sort of harmonization or a common license that would make this whole process easier. And there also seems to be a lack of motivation for the providers to harmonize and standardize those licenses, and to indeed sort of boost the uptake of Earth observation data, and therefore supports further commercialization of EO-derived products and services on a larger scale. What do you think, from what you've said, are, say, the top three or the most important things for industry players to keep in mind when thinking about the process of commercialization of Earth observation data? Again, considering they may not have access to specialized legal advice, what is really something that should be at the forefront of their mind? I know that during your presentation you gave a number of different sort of tips to look out for specific aspects of licensing and contracts and intellectual property rights. But what do you think would feature on the top, if you can make such a list? I know it's not an easy question.
You asked for 3 points, so let me try and give you 3 points. one, make sure that whatever you're getting from a third-party source is as clean and straightforward as possible, so that you know what you're getting. Secondly, make sure that you know with as much certainty as possible what intellectual property rights have been created in your derivative product. So you're taking first something from someone else to create what you're going to do. So make sure that you understand what you're getting, make sure you understand what you're creating, and then maximize the opportunities you've got to commercialize, to derive profit. In other words, where we started with my presentation, by making those rights available to third parties. And I think that just means knowing your market and selling it in the most effective way through a well thought out license. It doesn't have to be a complex agreement, but it does need to take account of the kind of things that I've spoken about. So really my 3 points go to input, creation, and output, if I can put it as bluntly as that. And I know that each of the input, creation, and output factors have several strands to them. But if you think about it in those ways, input, creation, and output, it may well help to focus your attention on what those three things between them capture for the people who've been listening to this presentation this afternoon.
Thank you. That's a brilliant summary. I don't want to hog the opportunity for anyone else to ask questions. So if you do have any questions, please post in the chat or unmute yourself. Otherwise, I do have one last one to ask, and that was in relation to the commercialization process, and perhaps also connected to the second session today. Is there any particular documentation that companies should maintain in relation to their intellectual property rights or third-party rights or anything else that they are using in the commercialization process? Anything that you think is worth mentioning, both for making sure that you have trail of what assets you have used, what assets you have created, what assets you are licensing. And I know that this is then something that Chris is going to talk about in more detail.
Speaking as a transactional lawyer, the one thing that clients are not very good at is keeping control over the agreements that are generated during the course of their commercial work. They often treat an agreement, for example, a license, it might be a license in from a third party or a license out to one of their own licensees, as a kind of document which, once it's been signed, can be put into a drawer. That's wrong. They are live agreements. They need to be thought of as dynamic agreements. And I think that businesses, if they could keep a record, perhaps just a spreadsheet of live agreements, of rights coming in, of licenses going out, it makes life a great deal easier if you're trying to, at some stage in their lives, perhaps sell the business or sell some of their assets, because somebody coming in to do due diligence will be much more impressed if they think that the business has thought about its licenses in and licenses out. It makes life a great deal easier because you know what's existing, what has to be looked at, what has to be refreshed, perhaps something that has a termination date and so on. Many businesses don't do that. So I think keeping a check on your contractual commitments and your contractual entitlements is really not a bad thing to do.
Thanks for your answer. And we have Daniel who would like to make a comment as well. Daniel, the floor is yours.
Yes, thank you. Thank you very much. Sorry, I'm on sick leave, in fact, so sorry if my voice is. I'd like. I understand the and I thank you for this presentation. That this is on commercialization, and it's also using your experience as a lawyer in those issue. I'd like just to make a very brief point on the beginning, just for the audience. The situation, the legal situation is a bit simpler than it may seem when looking at your first part. So there is a new regulation for the space program, which is now the regulation 696 of this year. And in those, you would have the definition of what is the Copernicus data, the Copernicus information, third-party data, in situ information, and also the licensing. So what happened, of course, is over the year, each time there is a new multi-financial annual funding for the program, there is a new regulation. So there could be layers of those. And in particular, also, as you see, it's a partnership program with ESA, and ESA is also at the beginning putting some notice for the Sentinel. So I can understand that there are different acts. It's very simple. If I can take the 4 categories in this, on the ownership of tangible and intangible, of course, it looks at the whole program, including the satellite flying, ownership of the satellite flying. You have the ownership of the Sentinel, and you have the data, and you have the data policy for the Sentinel data, which are pure Sentinel data, and this is free, full, and open. Nobody owns any prior rights on those. EU owns it. And then you have the information from the services, and there you have seen those information, the word information used, and we are using it for the services. And then there is the third-party data, and this comes from the commercialization. We are buying through ESA license to commercial providers, and there where you are seeing those primary data, secondary data, there we are really entering into an issue which is what you are addressing, the commercialization of those data and the difficulty to have such a license. And in particular, because we are asking ESA to negotiate those licenses in order for us to be able to distribute the service information. So that you are talking about input. Input is the commercial data, output is the service information. And we want to put on the market, free, full, and open, the service information. So for this, we need to negotiate specific license to the commercial to be able to license to the user a free, full, and open. And of course, we are putting in the data policy limitation in case we are not succeeding, because it may be the case where we are not succeeding, and therefore we would need to put limitation in our product, and those will not be free, full, and open. So there's a full set. It's a bit simpler, although still complex, I cannot understand, a bit simpler. So if you refer to the new regulation with the definition and then the article 53 on the data policy, then you would have the full picture, knowing that the delegated regulation is indeed dating back from the old time of GMES, and it's still, in fact, en vigueur, in force, for what does not contradict the new regulation. A bit simpler, not fully simple. Thank you. And thank you very much for the presentation.
Thanks, Daniel.
There would be one question, though, that I would have, and it's always with the derivative. I must say that from my understanding is when you have a derivative, it still means that you have in the derivative product the IPR of the original provider of the work. If we take the commercial world, they are providing their data from satellite. We can discuss if there are IPR in those data, difficult point. Let's take it that indeed they've made some transformation and there are IPR, don't want to discuss that. But then we are negotiating. Are we still going to call that the service information a derivative product, while we are distributing on the free, full, and open, which means that we have purged it from all the IPR from the previous owner? It's just a question of those words that you are using on derivative, because for me, it means that there would still be IPR from the input data.
I think it's still a difficult question for me as a relative newcomer to this field to work out precisely what intellectual property rights exist in the raw data. I certainly don't dispute the fact that the European Union considers itself the owner of relevant intellectual property rights in raw data. I have some difficulty in understanding precisely what those intellectual property rights are at the moment. I don't disagree with you that if I'm taking a license of something in which intellectual property exists from a pre-existing owner, then I've got to acknowledge those and have a relevant license to use when I create a derivative product. But it would be nice to know precisely what those intellectual property rights are defined to be, and if they're being made available because they emanate from raw data on a free, full, and open access basis, quite how I'm intended to acknowledge them, other than by simply acknowledging their source in my derivative product.
Yes, thank you very much. I fully share the view. Again, on the Sentinel data, the EU claim a kind. We are not the issue of the ownership and the words. Just to make the big distinction, the program is using ownership for tangible and intangible, but it is for the whole program, including all the IPR and so on, which may not be in the data. So we are not saying that there is IPR in those data. And if you look into the rights that we are saying the right of use. We are not providing a license on the IP because we are not recognizing the fact that those are IPR. But we need to give to the user the right of doing something. If not, they are going to ask them, what do I have the right to do? So if you look at the data policy, we are not saying that we have the IPR rights. One thing that we do not say either is about the database, and where we could have said, and this I must say that at this point, we would have lost a lot of our users because it is very complex for them to understand what are the rights they would get if we were going to put the IPR on the database.
Right, thank you for that clarification.
So again, the ownership, it is for the whole program, the 5 billions, including the satellites flying, the buying of the data. But for the data itself from the satellites, there is no claim of IPR on the data from the Sentinels. We are claiming ownership because it is an easy way out, but it would be data holder nowadays that we could use, and that would be perfect.
Michaela,
Daniel, Chris has a follow-up question.
Yeah,
Comment perhaps.
It's actually a comment on that last point. And I must admit, I have not, unlike John, been through all the foundational documents for Copernicus and Sentinel. But my understanding is that unless there is specific legislation conferring some unique kind of intellectual property right in this data, then the principles for deciding what rights exist in it will be those of existing European Union intellectual property law. And if it's raw data from satellite observation, then there will be no copyright in that data. It's pure information. There's no intellectual creativity in it. It doesn't meet the test for copyright. It's probably potentially a database, but the problem is it's not structured or organized in any way. So even then, the feed of data is probably not protected by database right either. And so it seems to me that these statements in the Sentinel terms and so forth are merely kind of phatic utterances saying, look, if anybody were to find any intellectual property rights in this, the European Union owns them, but we're licensing everybody freely to use them anyway, so you can in effect ignore them. So I would say that as a matter of practicality, if you're receiving raw data from satellites, from these satellites, then you are able to use it without worrying about there being some kind of rights in the European Union that might subsequently get enforced against you. And I think in particular that's relevant for database right, because database right doesn't follow on in the data. Database right says if you create a database, you can control extraction from it and utilization of it. You've already given people the right to extract and reutilize. The right doesn't impose further controls on what they then do with it under database right. But I mean, John is actually more the expert than me on this, so I defer to him if he says, no, I don't think you're quite right there, Chris.
Well, I think the point you've made is a perfectly good one. It's an interesting question to say, but what property rights have you got in this raw data? And if you can't answer the question, then it raises an interesting sub-question. On what basis do you then grant a license? Because when I look at the documentation in front of me from the European Union and the European Space Agency, it is clearly predicated on the basis that they own something in the raw data. Because had that not been the case, they wouldn't be offering the right to reproduce, to distribute, to communicate to the public, and so on. All of those terms are consistent and redolent of a license agreement from intellectual property rights. But if you can't then define what those intellectual property rights are, then it becomes more problematic. They're creating ostensibly a contractual right, as you have in a normal license, for somebody to use. And I think, Chris, all that they're doing is to say, well, we've collected all this stuff. We're just not too sure what we own, but we're going to give you the right to use it anyway.
Exactly.
If I may on this, again, there's a misconception that there's two types of data. There's a third-party data, and therefore you have the license for the use of the third-party data, which is the data which has been negotiated by ESA with the commercial providers. Those commercial providers are claiming IPRs. We were not going to say you don't have any IPR in those data. You will not find any claim for IPRs in the Sentinel data. If you look at the data policy, you will see that indeed we are giving the right. If you read it, just this is Article 53 of the new regulation. Copernicus user may, on a free and worldwide basis, reproduce, distribute, communicate to the public, adapt and modify all Copernicus data and information and combine them with other data and information. And of course, you will recognize those use as mimicking the one of IP. But we are not saying that we are owning the IP. The only thing is we are providing it to the user. When you are talking about unstructured data, those data are effectively in database. You need to look for those data. For looking into those data, they mean that they find their way in indeed a search way of getting access to it, therefore a database. Now we can get into those kinds of case of the database. The issue is that there is a European Court of Justice case. I don't remember the case law, in fact. I think it was on betting, and the database for this betting society was an ancillary product. Most of the money they were getting was of organizing those tournaments, whatever. And then there is a copycat of the database. And the Court of Justice say you cannot claim the sui generis right because it's not the thrust of your investment. And in our case, we would be paying 5 billion euro for those. It's not to have those database on the sentinels. Of course, it is the end product that matters for the distribution and use, but where the cost goes into is into building effectively the satellites. And therefore, the investment for the database is not the most important part. And therefore, you would not be able to claim the sui generis case. Now, I don't know how long this type of case can hold, but this is, again, something what there is a database, but we are not putting and claiming it because of this case, and also for a question just of simplicity for the users.
Thank you so much, Daniel. I think this late conversation only shows how complicated the issues are, and trying to interpret and understand them and apply them in your business strategy and intellectual property strategy without really having the necessary expertise and perhaps legal advice may prove very difficult, if not impossible. Thank you very much, John, for your presentation. It was most enlightening. And I would like to now move on to our second session, where we welcome Chris Reed, who is Professor of Electronic Commerce at Electronic Commerce Law at the Center for Commercial Law Studies at Queen Mary University, where he was formerly director of the center. Chris has worked exclusively in the computing and technology law field since 1987, and he's been teaching LLM students at Queen Mary from all over the world. He has published widely on many aspects of computer law. His latest books, one of his latest books being Rethinking the Jurisprudence of Cyberspace, published together with Andrew Murray in 2018. Research with which he was involved in led to, for example, the EU directives on electronic signatures and on electronic commerce. Chris, your session kind of nicely fits in with what John has been talking about, because you are thinking about what intellectual property law, intellectual property rights can do in terms of protection of intellectual property assets that are based on Earth observation data, potentially services, and also in terms of enforcement, and whether perhaps in certain circumstances, intellectual property law might not be the most immediate mechanism, whether legal or technical, to rely on, because perhaps it's not the most suitable one. It may be too complex to understand and to rely on. It may be perhaps expensive in terms of implementation or enforcement, and you will be looking at alternatives. What else is there that companies can use to really build a robust and ambitious strategy on how to protect their intellectual property assets, given that you have so adeptly managed the sharing and moving on the slides for John? I'm hoping you will have similar success when it comes to your own presentation. I'm handing it over to you. Thank you, Chris.
Well, thank you, Michaela, and I do indeed hope that that my slides achieve something. Yes, fingers crossed. Right, I'm not actually appearing in the middle at the moment, so let's pin myself. There we are. Right, I can see myself now. Yes, maybe I should just give a little bit of background more background about myself, because I think the advantage I have is that I'm actually not coming at this as an intellectual property lawyer. I have done some practice, not as a partner in a law firm, but as a consultant. And at the height of the dot-com boom, I was spending 2 days a week in practice with law firms in the city and doing an awful lot of online transactions relating to data and services, where, to be honest, at the time, you know, year 2000, give or take, 2000, 2001, nobody had any real idea what intellectual property in these information services amounted to. And so we would start from the proposition perhaps that there was no intellectual property involved, and think about devising ways to achieve the commercial relationships that we wanted to achieve and to exploit the things that our clients had come up with. So what follows is really a presentation about what would happen if you didn't have any intellectual property rights at all. So let me share my slides, and if this works.
Yes, we can see it.
Yes,
amazing. Thank you.
So my title is Protecting EO-Derived Products and Services Through Technical Evidence and Contracts. And I'm going to focus mainly on contracts and just really mention technical evidence in passing. But we might come to that in the question session afterwards, because technical evidence is going to be very important, but without the contracts, it doesn't achieve anything. I'm really picking up on John's point that you won't get paid without a contract. So you need to achieve some way of making contracts with your customers who are going to be paying you money. That's ultimately what you're trying to achieve. And then, as well as that, you're also trying to preserve your product or service so that your commercial exploitation of it doesn't rapidly reduce its value to nothing. And those are the two main things that you're trying to achieve. So let's start with ownership, because it is very difficult not to think about the products and services you developed and the data that you have in terms of ownership. I actually did some theoretical research on this recently and discovered that there's an awful lot of work by psychologists on the psychological sense of ownership. So even if people don't actually own something, they value it as if they do, and they're not prepared to let others use it or to exploit it because they feel ownership rights in it. And this is definitely a thing that influences people. I've discovered that in commercial transactions, people will ask large sums of money for access or use of something in which they have no rights at all, because they feel as if they own it. And that's often a barrier to reaching a commercial agreement. I think the starting point is this, and I think it comes clearly out of John's presentation, that intellectual property law confers ownership on what are artificial information constructs. The actual information itself sits there, not owned by anybody, but you can do things to it to turn it into something that you might have intellectual property rights in it. So you can use the information to produce a creative work, and that might give you copyright in the creative work, but not the information, but the artificial construct you've created. The work is protected by copyright. You can turn it into an invention, perhaps, and at that point you might get a patent for it. Or you could make it into a database, and then you would have database right in it. In the EU and one or two other countries, database right does not exist all around the world. So that gives you a problem if you're relying on database right in the EU and want, for example, to exploit your data in the US, because there you have no database right in it at all. Now, Earth observation data isn't any of these without further work. So one option is to say, okay, before I exploit my Earth observation data, and maybe the data I've derived from that through analysis and combination with other sources of data, maybe I should artificially turn it into a creative work or an invention or a database, and then that will at least give me some rights to exploit. But I'm going to ask, do you really need to do that? Do you have to own something to exploit it? Or if you have control over the data that people want access to, is that enough to allow you to exploit it? Well, the answer is that control is valuable. If you are the sole source of control over access to the data that you have, you can exploit it using a contract, because without access, others can't use your data. So under a contract, you grant them a right of access. That's a value to them. That's what they're prepared to pay you for. That's enough to underpin the existence of a contract in which you impose further terms and conditions on them, including an obligation to pay you. So if you control access, others can't use the data, and they also can't then incorporate it into their own products and services, which presumably is one of the reasons they want access to. So how do you give them a right of access, or how do they get a right of access? Right. Well, if you are the sole source of control, then they will have to get a contract from you, unless there is some other mechanism they could use. I mean, one possibility, if you are effectively the monopoly source of the data, which I guess would really mean if you actually own the satellite or have exclusive rights to receive the satellite feed, then competition law might order you to make that available to other people on fair and reasonable terms. But if you have taken, let's say, data from these satellites, which you receive under the license from the EU, whatever that means, license means in legal terms, which everybody else is free to use, and then you turn it into some useful data product by analyzing it, mixing it with other data, combining it, structuring it, whatever you might be doing, and you don't have a monopoly over the raw data you're using, I don't think the courts will ever use competition law to force you to grant access. So a contract is the only way that somebody else, your customer, can get access to this data. So it's quite possible to use contracts to exploit data that you don't own, so long as you have exclusive control over access to it. Now, there are two problems with contracts, and this is one of the reasons that people get interested in intellectual property law. Because if you have an intellectual property right, then that property right gives you claims against third parties, even if you have no other relationship with them. So if you have a copyright work and somebody else copies that without your permission, they've infringed your copyright, you have a legal claim against them, there's no need to show a pre-existing relationship. If you don't have an intellectual property right, then the only way you can impose obligations on them is to make a contract with them. So what this means is once you hand over your data or your information to your customers, one of the things you're concerned about is that they might hand it on to other people, and you won't have a contract with those second recipients, so you won't be able to control what they do with it. And if your data is licensed by 2 or 3 people and they give it out for free to lots of others, it immediately loses its value and you cease being able to exploit it. So what you'll need to do in your contracts with those who want access to your information product is you'll want to control further transfers of the data, and we're going to talk a little bit more about that later. And you also might want to try and leverage the law of breach of confidence to help you, because that might be some way of making claims against third parties, even if you don't have a contract with them. So again, we'll look at that in a few minutes. The other problem you have with contracts, which is perhaps not so serious, is you might well have fewer rights if the other party becomes insolvent. Let's suppose that one of your customers has received from you a large amount of information as part of your product, and they're storing it on their computers, and then they become insolvent. What happens then is that the law will usually have somebody appointed, an insolvency practitioner, to wind up the company. And the first thing that person will do will be to disclaim the contract with you, so they don't have to pay you any more money. And then they'll look at the assets they've got and they'll say, can we exploit the assets? In this case, all the information you provided. And immediately they'll be going, well, you have no property rights in it, so we'll just exploit it anyway. So that is potentially a problem. That's an area where intellectual property rights will indeed enhance your position. What about confidentiality clauses? I mentioned using the law of confidence to bolster your claims and your control over the data. Well, the first thing is that if you are the only one who has access to that data, then some parts of it at least will be confidential to you. There's no need for the data to be unknown to anybody. The question is whether or not you control access to it and it's not generally known to other people. That's almost certainly going to be true. So when you're handing it over to your customers, you are handing over information that is currently confidential. The problem is that confidentiality is lost if other people have access to the information, unless they accept access to it on terms that it is confidential. If they agree with you that they'll treat it as confidential, then that means they have an obligation not to disclose it to other people. So this is why you will always find in any commercial exploitation agreement that relates to information products a relevant confidentiality clause. And one of the difficulties is going to be describing which bits of the information product that you exploit are actually confidential. Clearly, the underlying Copernicus data, for example, is not confidential. Anyone can have access to it. But the things you have done to that data and the results you have generated, they are potentially confidential. Now, if this is confidential information and somebody uses it in breach of confidence or even receives it in breach of confidence, then you have a number of legal remedies against them. You can potentially claim damages, compensation. Even more usefully, you can obtain an injunction, a court order, ordering them not to do things with the data. And you could also get an order to deliver up the data. So these are very useful protections if you can maintain confidentiality. And we'll look a little bit later on about how you do that when your customers are going to be using your data to make down market products, downstream products that other people will use and therefore will have indirect access to the information that you have provided in the first place. So one of the issues that you have in this kind of contract is controlling the use by your customers, what I'm going to call the first use of the data. Now, because currently you control the whole thing, you control access, you can include almost any restrictions that you like, so long as you're not asking people to do something which is actively unlawful. Right? So you can limit their use of your data as much as you like. You can tell them they can only use it for their own internal purposes and not use it to make products or services for other people. You can say, all right, you can turn it into other products and exploit them yourself, but here are the conditions under which you can do that, and here are the limitations on what you can do. Secondly, you'll obviously want to prevent them making that information available to third parties. And given that you want to control the downstream use of your data, because once it gets out of your control, then you have nothing on which to base claims for payment, then you're going to, if possible, want all those who receive access to your data further downstream to enter into a contract with you. I'm calling you the data owner, but I've put it in inverted commas because you're not really owning it in legal terms, but you are treating yourself as the owner and believing you own it, and these people are also treating you as if you own it. So this is the, if you like, conceptual structure we're using. It's like exploiting something that you own, except for the slight difficulty you don't actually own it, but you do control it, and control is important. And then also you want provisions on financial return. So there'll be fees for getting access to the data, very obviously. That's the kind of subscription model that John was talking about. But if on top of that, your customers are going to be exploiting the data to make money for themselves, for example, by building it into new products and services, you might want some share of that return that they get. You might want a revenue share. Maybe it's X% of the revenue received or the profits made. You might want a royalty, which is X% of, if you like, the selling price. There are lots of ways of coming up with formulae for financial return, and that's a matter for commercial negotiations with these people. But if you don't have provisions on financial return, you won't get paid. And the whole point of this, to exploit your information product, is in the end to get paid. Now, I said in theory you can include any restrictions you like, but when might these limitations not work? Well, one possibility is competition or antitrust law. And to be honest, understanding competition and antitrust law is a specialist field. You really need lawyers who understand not just the wording of the law, but actually how it's understood and interpreted by bodies such as the European Commission, DG Competition, which is a very powerful and important body, by the US antitrust enforcement bodies, and so on and so on. So you need to know, you need quite a lot of expertise to understand competition or antitrust law. But in general, if you are not a monopolist in the information and you're not using these limitations to help you to exploit some kind of secondary product, then you're probably not at risk under antitrust law. And the other reason your limitations might not work is if you are supplying your information products to consumers. When it comes to consumers, all bets are off. It's really very, very difficult to use contracts to place controls on consumers. Consumers essentially get a free pass, at least under European Union law. So, all this stuff about controlling the first use of data becomes not quite irrelevant when dealing with consumers. You could reasonably limit them to using it for their own purposes, not disclosing it to other people. That would be okay. But if you go much beyond that, I think it's likely that you will be in breach of the unfair terms in Consumer Contracts Directive, and your clause will be unenforceable. What about third-party uses then? Suppose that your customer, the first user, is going to be allowing other people to have access either directly or indirectly to the information that you are exploiting. Well, clearly, because you currently have no relationship with those third parties, you will need this first user to help you out here. So your contract with the first user must oblige them to arrange some kind of controls over the use by the people to whom they exploited, the third parties. So ideally, you'd like to be a party to any contract under which information is disclosed. Or you would like the new recipient to enter into a contract with you. Only the first user can organize that for you. Now, that might not be commercially practicable, but if it is, that can be quite effective. A second way of protecting yourself is to allow the first user to disclose your data or information product only on terms that it is confidential. So the third party who receives it undertakes that it's confidential. That means that you have a right against them under confidentiality and trade secret law. And if they start to misuse your product, then you have a potential claim against them. And the third protection you might want to build in is some right to compensation or indemnity from the first user if they simply hand over the data without imposing these obligations on the third party user. Now, this is where evidence becomes particularly important, because you are taking raw information from satellites, which I'm pretty certain nobody owns any intellectual property rights in it, at least by the time it comes into your hands. You are turning it into something which has commercial value, whether by structuring it or combining it with other information or turning it into an information product. But by the time it's been through 2 or 3 other people's hands, all signs of what you've done could have disappeared. So one way of strengthening your legal possession is to be able to prove that these rival information products that are produced by third parties some way down the line, nonetheless derived from the information that you provided, and in combination with the contractual terms that you've entered into or the confidentiality that's been imposed on them, you are able to show that it is a breach of their legal obligations. That requires you to produce evidence that you're the person who provided the information in the first place. So how would you provide that evidence? And that's a practical question which I can't answer in the abstract, because it depends very much on how you are generating your information product and how you're exploiting it. But some obvious sources of evidence are things you'll all understand. Right? If you're providing access to your customers, then you will almost certainly have logs of who got access. Now, those logs might be currently set up purely for the technicians to look at, to sort out problems. So it will be worth discussing with your legal advisors, right, what can we do to turn these logs into more useful kinds of evidence? What kind of information should we collect? So you might, for example, only be logging the fact that somebody had access, that they had a valid username and password, and that maybe the IP address from which the access came. That's helpful. Be even more helpful, for example, if the log contained the username. So now you knew who had actually had the access, and you could prove it by putting your logs before the court. A second possibility is watermarking. There are lots and lots of ways of attempting to watermark information products, but one of the most common ones is simply to seed the products with various bits of untrue but irrelevant information. So on maps, for example, there are often irrelevant features on maps, like a disused church or a water tower or something or other, or a little stream that doesn't exist. And then if anybody else reproduces a map with the same erroneous feature on it, that's pretty good evidence that they took the data from your map rather than generating it directly themselves. But there are more sophisticated methods of watermarking than that, which technologists can advise you about if you think it's important. And a final thing which is well worth thinking about, particularly as we've already heard from Craig, blockchain plays an important role in the distribution of this Earth observation data. You might seriously consider exploiting your products via a private blockchain. And the big advantage of a private blockchain is that you would be controller of providing access to the blockchain, so it would be a permissioned blockchain. You wouldn't have, therefore, access to the identity of all those who are granted access. So, for example, if your first customer, your first user, wants to give access to a third party, in order to achieve that, they will need to get a key, to a private key, to access the blockchain. You are the issuer of that private key. At that point, you take identity evidence from this third party, you issue the key, and then you have on the blockchain evidence that actually it's the third party who had access to your data. And you can't show what they did with it once they got it, but you can at least show that they had access to it and that they took some data off the blockchain. So what kinds of contractual structures could you operate in order to exploit your information and information products? Well, there are two possibilities here. One is to try and do it using simple bilateral contracts, and that's what everybody will use, at least initially. So what that means is that each of your data users will have a contract with you, the data owner. And that contract will set out what they can do with the data, that it's confidential, their promises not to disclose it to others or to only to do so under certain terms, obligations to pay, and so on. Now, if your relationship with all your users is the same, if they're essentially just consumers of the information that you provide, this is quite simple, and you can have a huge number of contracts and it can work. A typical example might be Microsoft. Every user of Microsoft Windows has a contract with Microsoft, which is a software license to use Microsoft Windows. They are all the same, except they've been nationalized for different national laws, but they all contain the same obligations. That's because every one of those relationships is the same. As numbers grow, however, it can be quite difficult to keep managing a set of bilateral relationships. And certainly, if they move beyond simple bilateral relationships, so now that you have downstream third-party users with whom these original data users have to create contracts with you so that you have a contractual framework with the third parties further downstream, that becomes immensely complex and very difficult to manage. And it's a very tough decision as to decide how much of these relationships should you, the data owner, control, how much of it do you leave just trusting that your users will do what they're required to in a contract. And in making those decisions, you have to remember the point that John made, which is also my own experience, which is that people will spend months negotiating a contract, arguing over the tiniest points of it, walking away triumphant when they finally get what they want. You produce the deal in a commercial contract, could be several hundred pages long. Everybody signs it and has a glass of champagne, and then the contract is shut away in a drawer. Nobody ever looks at it again until something goes wrong, at which point they look at it and they go, oh dear, what we're doing now has no relationship at all to those documents. Right? How do we sort it out? So managing a contractual structure is really very complicated. So one possibility, if your exploitation grows into something quite complicated with lots of different participants at different levels who have different rights and different obligations, is to consider building some kind of multilateral contracting structure, usually via some kind of rule book for sharing the data that you are providing. under that model, you have essentially a set of rules that say, if you're a recipient of data of the following kind, then these are the obligations that you have, and these are the people you have them to. So it's quite easy to set out the structure of the whole thing and the obligations that people have. And that is put together as a contract between the data owner and every user, and between each user and every other user. This kind of structure is seen in, for example, in SWIFT, which is the worldwide financial data sharing system. Under SWIFT, there are hundreds of banks involved. There are hundreds of other thousands of other recipients of SWIFT data. All these people are exchanging messages between each other. The only way to control the legal obligations of those involved is to have a rule book to which everybody signs up. But it doesn't have to be as complicated as SWIFT. There's also a system for international trade documents called Bolero, and that has a rule book structure, even though the numbers at any one time who are actually using Bolero might be in the low hundreds or low thousands. So it's still a very complex system because all the parties are doing different things with each other and sharing different kinds of information. A rule book is hard to devise because you have to think about everything. Once you've got it in place, it's much easier to administer. So your bilateral system works nicely if everybody has a similar relationship with the data owner, that's you. If your information is being exchanged and exploited in complicated ways between lots of different parties, then maybe you want to be looking at some kind of rulebook model in order to make this work. So is intellectual property irrelevant? Because, you know, John spent an hour explaining to you how to deal with intellectual property, what you might produce that has intellectual property rights in it. And the answer to that, of course, is no, it's not irrelevant at all, right? Because if you do have intellectual property rights, or if you currently don't, but you could achieve them at a reasonable cost, then having those rights does a number of useful things. Firstly, it's a very useful backstop if your data comes into the hands of someone who has no contract, because now they have received your property. Right? In the same way that if they have your car, you can have various remedies to get your car back. The same thing. They have your information property, you have remedies to get that back as well, or to get them to pay you for using it. There's a second important point, which is that it gives perceived value and thus perhaps increased monetary value to your data. You know, if your customers realize that you have no intellectual property protection for your information products, then they might be less willing to pay you such large sums of money for access to it. Even though, to be honest, it's just access that they want. That's what they're really paying for. But because property has such strong psychological weight, they'll pay more if they think it's a property right. And this is why you will certainly claim, as the licenses that John was looking at do, that yeah, there are intellectual property rights. Your contract will certainly say that to the extent that you, the data owner, have any intellectual property rights, the customer acknowledges they're yours, promises not to infringe them, and so on and so on. But the perception of intellectual property rights, and certainly the existence, increases the value of your data potentially. And thirdly, and this is an important consideration, intellectual property rights can be very important for financing your business or for corporate valuations, for a share offering or an IPO, a placement of shares on a stock exchange, because property is an asset. It's an asset which has independent value. Whereas if you're just exploiting rights of access, your control over access, that's a contractual expectation that you'll get paid for it. That has less weight financially when it comes to valuing a company or lending money to it. Something else to think about is what kind of information product you're actually exploiting. Now, if you're largely exploiting real-time data, or at least data that's time sensitive, then that is ideal for contractual protection. That really works very well indeed. Because, well, two reasons. One is it's the least likely to have intellectual property protection in the first place. It's real-time information about something that's happening in the world as observed by satellite. Right. Its value is mainly its timeliness. And after an hour or a day or whatever it is, that data is only of historical interest. It's not part of the product anymore. Yeah, intellectual property protection is fleeting at that point. So that's ideal for contractual protection. I wouldn't bother much about intellectual property rights there, unless the historical data sets that are generated as this data builds up over time have some value. If they have some value, then it's quite likely they have some intellectual property rights as well. Bizarrely, although we talk about legal principles for deciding if something has intellectual property protection, in practice, what courts tend to do is to almost work in reverse. They go, this set of information is clearly very valuable, right? Because lots of people want to use it. If it's that valuable, it really ought to be some kind of property. So we're going to look quite hard to see if we can find a way to give it intellectual property protection. In the discussion, I can't remember his name, sorry, but one of the commentators in the previous discussion was talking about the database right case before the European Court. That's British Horse Racing Board and William Hill, which decided that because all the effort was put into basically arranging horse races, that's what all the money was spent on, and then the data was just arrived as a result of that, and now we were trying to exploit it separately, that there hadn't been enough investment in creating all that horse racing data to give it any protection at all. But if you look at subsequent cases involving football fixtures listings and data about football's games, lots of cases called Football Data Co, mainly involving a company called Sport Radar, you will see that the courts have changed their attitude to some extent, and they're looking at this and saying, look, we've got all these third-party companies who are desperately trying to get their hands on this football data. They are making a lot of money by exploiting it and not paying Football Data Co anything for it. This doesn't feel right to us. Can we somehow identify a difference with the British Horse Racing Board case? And indeed, they can identify a difference and are prepared to find some kind of property rights in that collection of information. So historical data sets are more likely to have IP protection. And also, it may be worth doing extra things to them, like structuring them into a database. And to be honest, you've probably done that already, to give them IP protection. But even so, contracts can enhance this. If you want to, if somebody has made a contract with you and they're doing something that is prohibited by the contract, when you bring this to their attention, they're very likely to stop because they promised not to. The fact that they promised is quite strong. And generally speaking, contractual disputes of this kind, where somebody is clearly in the wrong, are very quickly negotiated and settled very fast. If, on the other hand, you don't have a contract with them and you come to them and you say, look, you've never heard of me, but I have intellectual property rights in this thing that you're using, and maybe they've been using it for 2 or 3 years and have built up a nice business on the back of it, their first reaction is to go, no, I'm not giving in. I'm not stopping what I'm doing. So if you can make a contract with people, that really is a way of enhancing your intellectual property protection. And also you can then use it to extend your rights to some extent. So for example, if you were licensing something in which there was copyright, copyright law says somebody can't copy it, but it doesn't say within an organization how many people could use it. If the organization has a license to use the intellectual property, what does that mean? Does that mean 1 copy running on 1 machine, or 1,000 copies running on 1,000 machines, all within the same organization? That may be unclear under intellectual property law, but your contract can make it crystal clear in its charging structure. And then also, realistically, you have easier remedies, generally speaking, for breach of contract, because you just point at the contract term. Right. Intellectual property litigation is always expensive because there are so many arguments as to why what's been done is not an infringement of the intellectual property, or even that no intellectual property exists in the first place. With contracts, those kind of arguments don't happen. Right? There's no argument about the existence of the contractual right because the other party agreed to it. The only arguments can be about precisely what that right means and whether or not it has in fact not been complied with. So it can be quicker and cheaper to litigate over contractual claims. So that brings me to the end of the formal presentation part and a question and answer session. But I noticed that this is called a workshop. And I really think it's quite important that in a workshop, the audience does some work. So what I did was to come up with a couple of scenarios that I thought you might like to think about and maybe relate to your own experience. So if you have your own Earth observation related products that you're thinking of bringing to the market, and you can share information about them without damaging the confidence in what you have and disclosing your business plans, that might be quite useful. So I came across with two. Here's my first scenario. Under this one, we have a company called C-Space Incorporated. It collects Earth observation data about coastline movements from various satellite sources and combines them together with lots of other clever stuff. And what has happened is they've been approached by various service providers, or they have approached the service providers who provide marine navigation services. And they're going, yeah, it could be useful. There are places where the coastline moves 100 meters in a day, and that can be a danger to shipping. It's quite valuable to have real-time or very much up-to-date information or accurate predictions of what these movements are going to be. And so these service providers want to get access to this data. They want a real-time data feed, and they're going to offer two versions, a kind of full-fat version for merchant shipping that does long-term predictions and maybe integrates with navigation systems, and a kind of light version for pleasure craft, where before you take your yacht out sailing, you have a look to see whether or not the mud flats off the end of the estuary are likely to have moved much, so you don't get stuck on them and have to be rescued. Okay. And the questions you'd be asking here is, well, what risks is C-Space undertaking by doing this, by handing over the data to these service providers? What are their risks? And then secondly, what can we do to manage those risks? So that's scenario one. And I thought in scenario two, we go, okay, we have now a university, and they've discovered that C-Space has got built up some quite useful data sets going back over several years, and they want to use machine analysis on those historic data sets to predict future coastline movements. And of course, they want to publish their findings in academic journals, but also the university insists on commercial exploitation of the knowledge that's been discovered. So, okay, if C-Space lets them have access, what risks would that generate to their interest in the data? And what can we do to manage those risks? So, I don't have immediate answers, but I'd be very interested to hear what some of you think about those things. I'll stop sharing now, and so I can see the faces of anybody who has a question or comment or wants to come in on one or other scenario. And I can happily put these back up on screen if we need to. Over to you, Michaela.
Thank you so much, Chris, for another in-depth and detailed session on alternative mechanisms of how to control access and use of data that, while potentially being the most valuable aspect of the whole chain of the whole product development, they are potentially the least protected, and they require further processing and analysis, but are indeed at the core of any derived products or services. I'm really loving your two scenarios, and I just wondered whether Craig wanted to make any comments, because it is similar to projects that Argans has run in the past, and I'd be really interested to hear what were their company's considerations about exactly these risks. Craig, over to you.
I think the starting point I would say is that like many Earth observation SMEs, we're still very much in the R&D part of our development of products and services. So, for example, you talked about coastline movements. So one of our core projects is coastal erosion, where we look at a 25-year history through different satellites, imagery of movements of the coast in certain locations. Now, under that project, the locations that we've analyzed under the ESA project are open and free, and anyone can get access to that. But the knowledge and methodology and the ability to essentially map globally coastlines, depending on who and what wants it, that we would do under specific one-to-one contracts with people who want to do that. I suppose ultimately it would be quite interesting to develop a kind of subscription service, but that's a little way off because the amount of data to do the whole world is huge. And while we can probably cover single countries or large regions pretty quickly, the value of that data probably is still more to those local areas or to the governments of those countries or to the institutions that monitor the coastline for those countries. So the relationship is still very much to the public sector. And I would say that most of that would either be on some kind of grant funding for a specific area on a contractual one-to-one basis for that contract.
No, I can see that. I mean, as a starting point, you know, the obvious people who are interested in a long-term perspective on coastline movements will be, well, in particular, low-lying countries like the Netherlands or Bangladesh, or countries where the capital city is at risk of flooding, like the UK, where London is, you know, there's already a barrier to stop the flooding, and the whole of the southeast is sinking gently. So yes, it would be useful to know, you know, where it's going to go, and where not to build new developments and things like that.
But I think what we would consider our intellectual property is more in the processing software and the algorithms that we develop, and the actual end product is more a contractual relationship for that information. Clearly there are a huge amount of places. I mean, even most of the UK is defended. So the question is whether those defenses will stand up, and also looking at where you can manage retreat. But I think the big advantage of Earth observation data is often in countries where they struggle to monitor these kind of things without the continuous data sets of in situ or LiDAR data, surveys, etc. But the countries that can afford to support us to develop those products are the wealthy ones.
Now, I can also see it moving to private sector comparatively quickly. I'm just thinking of the huge amount of Chinese investment into building new ports, and picking a port location that's not going to sink below the surface of the sea in 20 years seems to be a sensible thing to check out before you put your money into it.
It's also amazing how many airports are not far from the coastline.
Yes.
Well. Yes.
Yeah, absolutely. Yeah.
Could I follow with a slightly different question, because it's one of the I think one of the challenges in terms of trust for Earth observation companies is a huge amount of the processing is now being moved to the cloud. So that means you're deploying your data in an environment which you don't have the same traditional control over. And then there's also the issues of exactly where in the cloud your data is, in which server, in which country, etc. And I think that's something that is the biggest challenge trust-wise, because you don't have the same control over the IT environment in which you're working. And obviously that brings in another level of complexity in terms of the relationship and the contracts with your cloud service provider and the obligations they have to protect what you're doing. And in fact, some of them may well also be involved then in the distribution of your products or services too.
Yeah, I don't know.
There's a comment, sorry.
Yeah, just no, that's right. So I was just thinking, also I was slightly distracted because somebody in the chat was wanting some information about this psychological sense of ownership.
Yes, curious for that.
I'll try and dig that out while talking at the same time, which will probably mean that I'm ineffective at either, but I'll do what I can in just a moment. Sure. Has anybody got a long comment that will give me just time to find those references?
I'm not sure it's a long comment, but it's definitely a comment on what Craig mentioned in relation to your scenario. And it's the sort of this disconnect between the existing business models and the manner in which the data is being made available, in which it is being exploited. As Craig mentioned, that a lot of the projects are mainly funded by grants, by public authorities. So on one hand, there is all this data that's available on a sort of full open and free basis from ESA, from the Copernicus program, but that in itself is not sufficient on its own to successfully to derive a successful commercial product, because often you need many more elements that are not available for free, that may be available on licensing terms or for prices that are not suitable, or they go in a complete contradiction with you being able to develop a commercially successful product and exploit it on a large scale. So again, from our research project, we found that really one of the main obstacles in the ecosystem is the lack of alignment when it comes to business models, when it comes to the technology available. So speaking about cloud computing services, there may be multiple platforms with multiple terms and conditions in different jurisdictions. There is the territorial nature of intellectual property rights of many national laws and regulations that impact on how you can use the final product or service, including national security, because obviously some of the data that you may be using can have impact on individual security of nations. So all that together presents really one of the main obstacles why many companies are not able to generate a commercially successful product, and almost playing it safe with publicly funded projects where they know that all the rights have been cleared, that they have the sufficient funding to work with the data and any third-party images, tools, and software they need to deliver the final product and service. And that seemed to be the theme emerging from the engagement that we've had with the various stakeholders. And I see that you have now shared the relevant documents.
Yeah, just managed to find through when you were talking. So excellent. Thanks, Michaela. Yeah, and you're right that this is a highly complex landscape. I mean, the scenario I was putting forward was a simple one, that you have a data owner, you have derived some basically free data from satellites, you've done clever stuff with it, you're now exploiting it as your own. But in practice, exactly as Craig said, you're doing clever stuff with it. You're probably bringing in data information from multiple sources, maybe stuff that is intellectual property protected. Even if it's not, it may be stuff that claims to be intellectual property protected and you're not sure whether it is or not, or you could only get it under contract in which you acknowledge that it's intellectual property protected, even if it isn't, and make various promises about it. Right. And this is, at the end of the day, where lawyers give the value, I guess, which is in making sense out of all that lot, looking at it and going, okay, you ultimately have an information product you want to exploit. So first question, how much of this source stuff is actually in there? Do we have any problems with the people who provided the source stuff? That's their first question. And often it can be a very helpful exercise, because they come back and they say, actually, there are only 2 of them you have to worry about. All the others, no problem at all, because of what your contract says or the nature of the right they claim or whatever. Right. And then we have these 2 who are potentially a problem. Right. And of course, there are different ways of dealing with it. And this is where you need a lawyer who's a good psychological match with your business. Because if your view is, I don't know, I want to modify my product to cut out these people and give them no claim at all, then probably I'm not the right person for you, because you want someone who's more litigation minded, who say, okay, we're ready for a fight on this one. Right. Or the alternative, which is more my kind of approach, is to say, why don't we go and talk to these people and say, we've developed this really interesting product. We have agreements with you to have access to stuff from you, and we've built that. Parts of this are reflected in the product. What would be a suitable deal that would make us both happy? But again, if a suitable deal can be done, it doesn't really matter about the intellectual property rights anymore, because if a suitable deal with all the people who are engaged in your product, right? And you've had good enough advice to weed out the others and say, we don't need to be concerned about them.
No, I think that's right. The biggest challenge that when we looked at the development of EO products is the huge amount of inputs. So there are a lot of different players, different intellectual property inputs, different consortia member developing different intellectual property throughout it, and that's quite difficult to. Well, it's quite easy to track if it's for research and development, but it's quite difficult to track if it's for commercial exploitation. I think the other point that you made earlier on about licenses and contracts, and we did have a discussion early on in our project with ESA about this, is whether as an industry, and with ESA being such a strong player within the industry, whether they could not support some kind of standardization of contracts for the industry, specific for the industry and for the type of exploitation of the data that we employ. We haven't had an answer yet, but it may be another project to work on.
Okay, well, there is actually one interesting possibility there. I'd thought about talking about it, but it did seem potentially off the point. But there is a concept called a data trust, which has been developing over the last few years. And initially, it began very much with the idea that, oh, this is kind of research data for public purposes that should be just dumped into a place where anyone can have access to it. But people like me have been working on it since then, saying actually it could also work with commercial parties for commercial sharing if they have a kind of common objective, a common set of interests. And effectively what you're doing there is building a collective rule book, but you're also building a kind of governance body as well. So what would happen is people like ESA and other providers would put their data into the data trust. They would have some say in the terms on which it could be exploited, but we'll leave the management of that to the data trust governance. Right? The data trust would, if you like, represent all the interests involved and have an overriding constitution that says, this is what we're trying to achieve. You know, lots and lots of better EO-derived products, whilst at the same time making sure everybody gets a fair commercial return for their input. And then they would license the information under those principles to people who are also members of the data trust, who might have an obligation to, I don't know, put data back into it, for example. Now, in a straight, commercial relationship where everybody is straight rivals, that's unlikely to happen. But it seems to me that in your space, you're doing coastlines, other people are doing agriculture. You have lots of interests in common and very little straight commercial rivalry at the moment.
Yeah, at the moment, we hope it becomes more commercial over time, but yes. And I think, of course, that also gives a lot of, that kind of idea could be very powerful, particularly for developing countries, to be able to make a number of choices on the impact of climate change, say on agriculture, forestry, the coastline, etc.
Yes, it does have a downside when it comes to investors, because there are lots of investors out there who are going, we're going to bet on you to blow the others out of the water. Exactly. And if your data trust structure stops you doing that, it reduces your investment value. So it's not all win. Yeah,
I mean, it may well be a stronger proposition for the academic institutions and public laboratories that tend to collaborate more than maybe the private enterprise.
Yes, no, I could see it working very well for universities, because my experience of university IP exploitation people is that they come at it from a patents perspective, and they have a very narrow concept of exploitation, very narrow indeed, with the result that not much happens.
Sure.
Thanks, Chris. I must say that this was actually my next question about data trusts, and you've already answered it, because I knew that you worked on research projects on data trusts, and that you are also on the cloud computing, legal cloud computing project at Queen Mary. So in both areas, you are the suitable experts to answer these questions. I also wondered whether an increasing sort of regulation, whether public regulation or private regulation as data trusts would be an example of, will mean that the value of the data itself will grow exponentially, the more limitations or restrictions, or the more detailed the rule book is on how data can be used, even if it means that it has been simplified to some extent, will also mean growth in value, and therefore then the value that can be exploited within the industry itself.
Well, certainly one big advantage of a data trust is a huge reduction in the opportunity cost of getting access to data, because you would have to go and speak to 20 different people to get data from 20 different sources. If it's all in the data trust, you speak to one person, the data trust. And on top of that, that has a published constitution and principles. You already have a pretty good idea of the kind of terms you'll have to be entering into to get access to the data. So it cuts down negotiation from 20 parties to one, and there are some things that you're stuck with, they're givens, so you're really only negotiating at the edges of the margins of your data access and what you can do with it, which is going to make it much simpler and cheaper.
Yeah, I think it is the negotiation costs and enforcement costs and costs associated with legal advice that are often the main obstacles for companies in the Earth observation ecosystem, and therefore a slightly slower uptake of Earth observation data for commercial exploitation as would be desirable. I just wonder whether anyone else from the audience has another question. We have answered Kira's question on the psychological aspect of ownership that you discussed in the beginning. I'm not sure whether anyone else has a comment in relation to the scenarios.
No, they're all keeping their commercial cards close to their chest.
Yes.
We're not telling you what our products are about and how we're thinking of exploiting them. I feared that.
Yeah.
No know-how is being shared and disclosed.
If we were physically in the room, I could intimidate people into
Sure. Yeah.
but that's not really possible on the Zoom platform. Yeah.
I might have one last question, if that's okay, and that is, as Craig mentioned, that in a space that ESA is such a strong player, and they do have potential to push for harmonization and standardization in this particular sector. But do you think that they are the best placed actor in the industry, or someone else should be pushing for greater alignment of the technology, the business models available, licensing terms, and so forth? Who should be driving this change for a simpler and more cost-effective environment? What do you think?
Right. Okay. I don't know ESA well enough to give a definitive answer, but I would say that it's not its core activity. Its core activity is putting very high-tech objects into space. That's what it does. That's what it focuses on. And the question of the onward exploitation of the data that's coming out of those activities, it's not the obvious person to even see the commercial opportunities and to understand the commercial interests involved. On the other hand, it has the position of a kind of independent third party who I'm guessing might be trusted to be disinterested by all the others involved. So it will be a very useful partner in any standardization exercise. The problem with standardization is the one that John raised in his talk at the beginning, which is that when you standardize a document like a contract, say a license of some kind, whether it's a data access license or an IP license, it doesn't matter. Usually what that means is it's designed to sort of work for sort of the majority of cases, right? So it's a best guess at what might work for most instances. Right? It will never be right for every particular instance. if you have something that is comparatively understood, I'm just thinking of, I don't know, licensing apps to people to use on their phone, right? The basic license terms for the software in the app are pretty much the same for all those. They've copied them off each other. They reckon they work pretty well for bog standard. You're a consumer, here is the app, use it or delete it. That's all that's going on. So their standardization is kind of possible, but that's because the activity's been around a long time and there are no nasty surprises out there that need to be managed by contract. When we're talking about something as, to take Craig again, you know, predicting coastlines, and then after 10 years, the government comes back and says, our airport's underwater and it's all your fault. You know, at that point, a kind of standardized set of terms probably won't cut it. That's the difficulty. So it's much more, if you like, what might be interesting, it would be standardized principles for doing these things. I'm thinking of the UNCITRAL model laws, say the UNCITRAL model law on e-signatures, which effectively told states, this is how you should regulate e-signatures, right? So a kind of a model for exploitation of EO data could be agreed by the industry players and could then be very influential because lawyers like John and myself would be going, okay, what's our model to start with when we're putting the contract together? Oh, look, there's this EASA sponsored model, which lots of people have signed up to. That looks like a good starting point for our contracts. Let's build on that.
Thanks. I wanted to ask whether you have a suggestion of an industry where this worked well, or a specific mechanism where this standardization was successful, and you came with e-signatures. Unless anybody else has any questions, Daniel asked whether we could have some outlines of an answer to the scenarios provided, whether you have the answers.
Well, of course I have some answers, but I don't have the answers. You know, I just have some answers. But if I go back and share that quickly so people can look at the two scenarios, I'll very briefly run through the obvious things that I think are worth thinking about.
Thank you.
I just need to find PowerPoint, which is hiding from me at the moment. It's got to be here. Come on, I was using it just a moment ago. Right, here we are. My problem is that I have too many windows open. So, right, okay, here's first scenario then. So, okay, we have these commercial providers of marine navigation services. They want to use Seaspace's data to build it into their marine navigation service applications, right? Okay, what are the risks involved? Well, yeah, one of the risks is probably these are big guys. Right, they're financially more powerful. So it would be very tempting that they simply, use their access to Seaspace's data to build their own commercial products. So one of the questions is going to be, what controls can we put on their uses to make sure that they are not building rival products to the extent we can control that, or at least if they are doing it, they're not doing it on the back of our information. Right, that will be one of them. And we control that through a contractual term, limiting the use they can make of our data, and confidentiality clauses as well. They'd be quite useful there. A second risk, which is pretty obvious to me, is that let's say a container ship manages to not to get stuck in the canal, but instead get stuck on a mudflat, which was predicted not to be there by one of these navigation apps. And okay, they sue the provider of the navigation service. The navigation service joins in Seaspace as a defendant and says, okay, we admit it, our app didn't work, but it's all Seaspace's fault. They should cover the costs. Right, how do we deal with that? We've got the kind of liability clause that John was thinking about. I think the point I'm getting at here is that this isn't enough detail in this scenario to actually answer all those questions. What you need to do is to do this kind of risk analysis and say, what are the risks I'm worried about here? And then think about what your contract would have to say. And at that point, your lawyers need to come in to help you in order to manage those risks. So I can immediately think of two. Give me another moment. I'll think of another two or three more. Okay. Well, one of them is quite simply that Seaspace's algorithms are incomplete, right? That they're good in some circumstances, but they don't work when it comes to typhoons. So the typhoon season hits, and suddenly the sea space data is wrong, and all the predictions about coastline movements are wrong, and ships are running aground left, right, and center. Right? That's another risk. Okay, that the data is not accurate in certain circumstances. So yeah, does sea space know that? In that case, they'll want to carve out the use in those circumstances. Right? They'll be telling these customers of theirs, look, this data is fine for normal circumstances, but once we get into chaotic weather systems like hurricanes and typhoons, all bets are off, and you either stop using our data or you use it at your own risk to carry on providing your marine navigation services. And yeah, if I were their lawyer, I'd be talking to them and saying, okay, tell me about your customers, tell me what they do, tell me what kind of predictions you've got, how does your software actually work? So I'd be finding more and more about the context, which would tell me more about the risks, and then I'd work out the interests and risks, and then I'd work out ways of dealing with them. Okay. Scenario 2, right? Well, the obvious risk straight away is we're handing this data over to academics, and academics are notorious sharers. That's how it goes. You know, first thing they do is they stick it on a server somewhere and put a web front on it and tell all their friends it's there. So, yeah. You want to control that, and given what I know about universities, if I were advising you, I'd say it's not enough to make the university promise not to do it. You also want the right to come in and audit what they're actually doing with it, because it doesn't matter what the university promises, the researchers are off on a little frolic of their own, and you need the ability to find out what they're actually doing. Okay, and the second thing is the commercial exploitation point, that, you know, given what I said about universities' abilities to exploit stuff commercially, I think if I was C-Space, I would want to be involved in the commercial discussions by the university to actually help guide them to an effective commercial exploitation, which gives me a suitable revenue share, rather than leaving them to go off on their own to do it. Because the risk then is that they will basically give away all my data for practically nothing, and with no return to me, and then come back to me afterwards and say, we're really sorry, we didn't really understand what we were doing when we entered into the deal, because we took a standard patent license and we tweaked it and we thought that would be fine, and it wasn't. Those two risks I see straight away.
Thanks, Chris. Again, brilliant summary. I think this brings us to the end of the workshop. I would like to take the opportunity to thank both John and Chris for joining us today and for contributing to developing best practices and strategies in this booming sector that is becoming one of the globally fastest growing sector with edge-cutting research and innovation. And I'm hoping that the participants will be able to build in some of these insights that you've provided today based on your experience and your expertise into their commercial practices and help them with successful commercial exploitation of Earth observation products and services. I'm going to hand over to Craig for final words. But before I do that, I also want to thank our audience for being here today, for their questions, for their comments. If you are going to watch this workshop later in your own time, please feel free to get in touch with us. We would be happy to answer any of your questions or your comments at a later stage. Thank you. Craig.
Okay, so thank you everybody for today. I think it's been really interesting and informative, and it brings, for many of us Earth observation companies, a better perspective on how we should look after ourselves and create greater value as we, I think, make it, for many of us, a transition from being very pure R&D to starting to get to the point where we have more commercial products that we can exploit and can sell. Which is really, I think, the objective of many of us. I'd like to thank Noam for introducing it with me, for Michaela for hosting and moderating it, and Chris and John really for your very informative both presentations and the discussions afterwards. Thank you for everybody for joining today. As Michaela said, recordings will be available, I think, through CCLS website, but we'll also then put it with the Building Trust documents that we're putting together on the Argans website. I hope you all had a very enjoyable afternoon and learned a lot today. So thank you to everybody, and particularly our thanks to ESA for funding this project, which is really interesting. Thank you very much.
Thank you.
Have
Bye,
a good
everyone.
evening. Goodbye.